The Schedule C bankruptcy form is important because it is the document that protects your property and prevents it from being sold or requiring you to pay out funds to your creditors. The purpose of filing a Schedule C in a Chapter 7 bankruptcy is to declare and classify any property or assets you believe should be exempt from the bankruptcy estate. In other words, it's a way to protect specific assets from being sold to pay off your creditors. Exemption is the process in which real or personal property can be excluded from calculation in the determination of what is due and owing to the creditors. All personal and real property will be included. However, the treatment may be different. Schedule C allows you to actively take steps to protect certain assets from being sold off during the Chapter 7 bankruptcy process. This can provide peace of mind and allow you to retain ownership of important possessions. Why you have to file a Schedule C? The bankruptcy process involves a trustee who reviews your financial situation and sells non-exempt assets to repay creditors. However, the Bankruptcy Code allows you to claim exemptions, which are legal provisions that protect specific types and amounts of property from being included in the bankruptcy estate. Filing a Schedule C is your opportunity to declare and justify these exemptions. Exemptions are crucial for preserving essential assets such as your home, car, personal belongings, and certain retirement accounts. Without exemptions, you might risk losing these assets during the bankruptcy process. Exemption laws vary by state, and there are also federal exemptions available. By filing a Schedule C, you declare which set of exemptions you intend to use. This ensures that you are in compliance with the applicable laws and can maximize your asset protection under the Bankruptcy Code. The trustee and creditors have the opportunity to review your Schedule C and may object to any exemptions they believe are inappropriate or excessive. This is a standard part of the bankruptcy process, and your attorney can help you address any objections. Federal laws versus the state laws. Both the federal government and each state provide exemptions that can be used to exclude assets from the bankruptcy estate. However, the law dictates whether you can use the state or federal regulations. Please go to the Bankruptcy Court website to determine the one that is appropriate for you. The following is a list as of April 2022. States that allow debtors to choose between state and federal exemptions: Alaska, Arkansas, Connecticut, Hawaii, Kentucky, Massachusetts, Michigan, Minnesota, New Hampshire, New Jersey, New Mexico, New York, Oregon, Pennsylvania, Rhode Island, Texas, Vermont, Washington, and Wisconsin. In these states, debtors have the option to choose either the state exemptions or the federal exemptions provided in the United States Bankruptcy Code, 11 U.S.C. Section 522. States that require debtors to use state-specific exemptions: Alabama, Arizona, California, Colorado, Delaware, District of Columbia, Florida, Georgia, Idaho, Illinois, Indiana, Iowa, Kansas, Louisiana, Maine, Maryland, Mississippi, Missouri, Montana, Nebraska, Nevada, North Carolina, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Utah, Virginia, West Virginia, and Wyoming. In these states, debtors are generally required to use the state-specific exemptions provided by their state's bankruptcy laws. Are you ready? Before you complete Schedule C, make sure you have your Schedule A, B before you. Your Schedule C Exemptions will be based on the answers that you provided on your Schedule A, B. Due to the various jurisdictions, we will be using federal exemptions for our examples. Remember, you must go to the website for the bankruptcy court in your jurisdiction and check the numbers that are allotted. These federal exemptions are from April 1, 2022 through April 1, 2025. Working on your Schedule C. Be as complete and accurate as possible. If two married people are filing together, both are equally responsible for supplying correct information. Using the property that you listed on Schedule A, B, property as your source, list the property that you claim is exempt. If more space is needed, fill out and attach to this page as many copies of Part 2, additional page as necessary. On the top of any additional pages, write your name and case number, if known. For each item of property you claim as exempt, you must specify the amount of the exemption you claim. One way of doing so is to state a specific dollar amount as exempt. Alternatively, you may claim the full fair market value of the property being exempted up to the amount of any applicable statutory limit. Some exemptions, such as those for health aids, rights to receive certain benefits, and tax-exempt retirement funds, may be unlimited in dollar amount. However, if you claim an exemption of 100% of fair market value under a law that limits the exemption to a particular dollar amount and the value of the property is determined to exceed that amount, your exemption would be limited to the applicable statutory amount. Things to know? 1. Dependent. Includes spouse, whether or not actually dependent, and 2. Value. Means fair market value as of the date of the filing of the petition or, with respect to property that becomes property of the estate after such date, as of the date such property becomes property of the estate. Valuing your property can be a sensitive issue. Keep in mind, the value is not what you paid, but what you can get for it today. The lower the better, but be truthful. Your exemptions will only go so far. The Chapter 7 trustee can sell or cause you to pay out of pocket to your creditors. There are 8 common exemptions. Please pull the PDF of the 11 U.S.C. 522 for reference. 1. The homestead exempt allows for individuals who own their residence in the amount of $27,900 or for couples that own their residence it is $55,800. Pretend that you own a home that is currently valued at $100,000. Let's say that you have a mortgage for $60,000. Therefore, you would have equity in the amount of $40,000. In order to arrive at the maximum allowed exemption, you would subtract the equity of $40,000 by the exemption allowed. If you are an individual, you will take $40,000 and subtract out the individual allowance of $27,900, which will leave $12,100 of non-exempt property. The $12,100 is the amount that you may be asked to contribute to your creditors, if there is no other exemption you can use. If you are married and filing jointly, the $100,000 value minus the current debt of $60,000, which leaves $40,000 in equity. The equity of $40,000 minus the exemption allowance of $55,800 leaves a negative $15,800 or less than zero. The entire property is exempt. 2. The second is the automobile exemption. It allows a total of $4,450. 11 U.S.C. Section 522, D.2. If you own more than one car as an individual or two as a married couple, the issue of necessity can become an issue. 3. The third is the jewelry exemption. It allows a total of $1,875. 11 U.S.C. Section 522, D.4. 4. The fourth is the standard personal property exemption, which allows a total of $14,875. 11 U.S.C. Section 522, D.3. This exemption states that no one item can be greater in value than $700. It includes household goods, furnishings, appliances, clothes, books, animals, crops, musical instruments, etc. Note: the maximum exemption is $700 per item. 5. The fifth is the wildcard exemption, which allows for a total of $1,475 plus up to $13,950 of any unused amount of the homestead exemption, which adds up to $15,425. 11 U.S.C. Section 522, D.5. This is the most valuable exemption because it could be applied to any category of exemptions, which is why it is a wildcard. 6. The sixth is the tools of the trade exemption, which is $2,800. 11 U.S.C. Section 522, D, 6. This is for a profession that requires the use of tools and other equipment, including uniforms. For example, a carpenter will need a hammer, drill, screwdriver, etc. Or a computer programmer will need a computer. The allowance. 7. The seventh is the allowance for claims of personal injury. The amount is $27,900. 11 U.S.C. Section 522, D, 11, D. For example, you were involved in a car accident. You sought damages for pain, suffering, and monetary loss. They were awarded to you. Any amount that is less than $27,900 is exempted. Any amount above can be used to pay your creditors. 8. The eighth is the allowance for the retirement account, which allows for $1,512,350 for IRAs and Roth IRAs. Most retirement accounts are exempt. Amounts above $1,512,350 can be used to pay creditors. Keep in mind, if money is transferred to a checking or savings account, it is no longer protected under the retirement exemption. There is an interesting exemption. Interest and dividends are allowed up to $14,875. 11 U.S.C. Section 522, D, 8. Many people think that they must be absolutely broke at the time of filing a Chapter 7 bankruptcy, but not necessarily. Let's answer the questions. 1. Which set of exemptions are you claiming? Check one only, even if your spouse is filing with you. A. You are claiming state and federal non-bankruptcy exemptions. 11 U.S.C. Section 522, B, 3. B. You are claiming federal exemptions. 11 U.S.C. Section 522, B, 2. 2. For any property you list on Schedule A, B that you claim as exempt, fill in the information below. A. Brief description of the property on Schedule A, B that lists property. B. Current value of the portion you own. Copy the value from Schedule A, B. Circa amount of the exemption you claim. D. Check only one box for each exemption. Specific laws that allow exemption. 3. Are you claiming a homestead exemption of more than $189,050? Subject to adjustment on the 1st of April 25 and every 3 years after that for cases filed on or after the date of adjustment. Please answer no or yes. If yes, did you acquire the property covered by the exemption within 1,215 days before you filed this case? Please state no or yes. Go to the additional page and complete in the same manner if you have additional property to exempt. Thank you.